A good percentage of Colorado license plates have already gotten one of these tickets from the Colorado Transportation Investment Office, CTIO. I'd be surprised if you haven't gotten one. $75 for crossing the double white line in or out of a toll lane. The state calls it a safety program, but they're using a statute for toll evasion, and that's where the legal argument gets kind of interesting.
It felt good winning for myself, and hopefully we can win for the rest of the consumers that are in the same place.
Attorney John Bolin says he's heard from hundreds of people since we first reported in March that he beat one of those $75 toll tickets in court, all because his ticket cited a statute for toll evasion. But he didn't technically evade the toll. Even though he entered the lane outside of an entrance, crossing the white line, his transponder paid the toll.
Our argument was, and will continue to be, that that has to be limited to the types of things you would do to evade tolls, and also that you have to actually evade a toll in order for this provision to apply.
A few things have happened since Steve on Your Side first reported John's win in Douglas County Court in March. We found another case in Jefferson County where a judge also sided with a driver who exited the toll lane right before it ended after he paid the entire toll. Again, he was cited for toll evasion. Now the state is appealing both cases and the definition of toll evasion.
They're really latching on to a part of the regulation that has a sort of a little bit broader catch-all language.
In Bolin's original case, a judge ruled the state statute granted CTIO the authority to enforce tolls not being paid. And if CTIO had been given other authority, it would have been provided in statute. That has not been done. The state says CTIO can interpret its own rules. In a brief filed in John's appeal, the state argues payment of a toll is not a defense to the act of toll evasion. And they go back to high school to explain that with the definition of avoiding or evading. Quote, if someone at a party is observed turning their head away from another person's gaze or shielding their presence from the other, it is common to state that the person is avoiding the other person, even if they are ultimately unsuccessful in that endeavor.
They want to argue that it's anything that you essentially could do that might evade a toll, even if you didn't evade the toll, which doesn't make sense to me.
So if you're trying to avoid something, you end up having to talk to them, you still apparently avoided them. The court hasn't ruled in either of these appeals yet, nor do they have anything in the schedule on the calendar for either of those cases. Bolin, by the way, says that he's considering a class action lawsuit if this appeal goes in his favor, arguing anyone who got one of those tickets and paid a toll shouldn't have been ticketed. The state told me they had no comment beyond the briefs filed in court. I'm Steve Stager, Steve on Your Side, 9 News.